we go. Okay, it is now 6 p.m. and I hereby call this Planning Commission meeting to order. Please rise for the Pledge of Allegiance. Commissioner Scagliotti, if you could lead us in the pledge. Thank you. Roll call, please.
District 1, Vincent Ringhayden.
Present.
District 2, Richard Way.
Present.
District 3, Robert Scagliotti.
Present.
District 4, Robert Gibson.
Present.
District 5, Celeste Toledo Bocanegra. Present. All commissioners are present. We have a quorum.
Wonderful, thank you. Department announcements, please.
Thank you, Mr. Chair, members of the Planning Commission, and members of the audience. Good evening. Abraham Prado, Director of Planning and Building Services. As you can see on the screen, this is another one application, a discretionary permit that would be reviewed by the Planning Department and then ultimately brought before you for a determination. It is a 90-foot tall monopine that is being proposed at off of Sealy Avenue and just in Aromas, just to the east of the county line, and it's approximately 9.7 miles west of downtown San Juan Bautista. So that's a conditional use permit application that we'll be proposing.
I just have a question. Are there pine trees in that area?
That is one thing that we'll be reviewing, and that's going to be part of the application when we do the site visit and so forth.
Pretty good.
For what it's worth, it is very near a street called Pine Tree Lane.
Really? I rarely go there, but okay.
Will it be aesthetically proper, or
That
will it
is-
just be a stupid sore thumb like the rest of them around the county?
That's one thing that we'll be reviewing during the application
I don't want to get too
process.
deep in the weeds with it. Okay. Thank you.
Thank you so much.
Oh, that was it, huh? Okay, very good.
There's one more announcement.
Oh,
We did call the commissioners, but we wanted to formalize scheduling a special meeting on November 6th at 6 p.m. to review a lot of code updates, including Title I code enforcement, Title VII cannabis, 7.02 and 7.04 hemp entities, Title 19, 19.43 cannabis business and use regulations, and comprehensive updates to Title 25.
fantastic. Looking forward to getting those done. Thank you.
Perfect, thank you.
Is there any general public comment? These are for items under the purview of the Planning Commission, but not on this evening's agenda.
I have no cards for public comment and no hands via Zoom.
Okay, thank you. Public comment is closed. Consent agenda. Are there any additions or corrections to the minutes? There was a spelling error, but I don't know if we want to. Page 23 of our packet, page 6 of 7, on the, must be the first set of minutes, there was a, on the top of the page, enforce the renal requirement. There should have been rental up there, but it's not a huge issue if it doesn't get corrected. Okay. Other than that, I didn't have anything. Did commissioners have any other corrections or changes to the minutes? Seeing none, is there a motion to adopt the consent agenda with that change?
I make a motion we adopt the consent agenda without change.
Is there a second?
I'll second.
All those in favor signify by saying aye.
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 Any opposed? Very good. Motion carries 5-0. Thank you. Next item on the docket, 7.1. Hold a public hearing to adopt a resolution with findings to recommend the County Board of Supervisors deny the request for an ordinance enabling execution of the development agreement.
Ariel Goodspeed, Principal Planner for the County of San Benito. And yes, so the Planning Commission voted on this item on September 18, 2024. And during this meeting, it resulted in a 2-2 vote not to recommend approval to the Board of Supervisors. to formalize this motion and formally deny the proposed development agreement under County Code 1911-08 requires a recommendation for denial is brought in written findings to Planning Commission to support that determination and to be considered by the Board of Supervisors. As such, staff brought findings tonight, and I'm happy to answer any questions on that resolution.
Okay. I just wanted to point out per our transaction of business, our rules, basically, item 9C, if there is an unbreakable tie vote, which we didn't try multiple times, but it was a tie vote to approve, so it didn't go anywhere, that the chair shall solicit findings for both sides and state those findings in the record. So what we should have ended up with was either continue the item if we were just deadlocked to another meeting where we had 5 commissioners, or we should have had an item with both findings for denial and approval. So we're going to have to figure out what we're going to do this evening, because as it was, we didn't actually vote to deny it. We just failed to get a vote to recommend to the board to approve it. So we're kind of in a gray area.
Can I say something?
Yes.
As I was absent that day, so going back to the video and looking at what Commissioner Chair just stated, I noticed that after the tie vote, there was no direction from staff or county council. So I agree with you on that as far as making another motion since I'm present now.
We have to, how do we proceed with a public hearing? Do we just rehear the entire thing, or what do we?
This was heard. We cannot rehear this. The people who are here tonight did not expect to be here for a rehearing of what we already covered.
Yeah, but we didn't deny it either. We didn't really do anything. That's the problem.
It was effectively denied by the 2-2 tie vote. I think tonight it's up to the chair, but I would encourage the chair to allow public comments on this item since it's an itemized piece in the agenda. Commissioner Bocanegra, if she's apprised herself of the materials and watched the video, then she is free to participate. That said, I think we should treat the 2-2 vote as effectively a denial and proceed based on that.
Mm-hmm. Well,
Can I, if okay, make a motion to take back the past motion of the tie and then a motion?
Yep. After reviewing the rules we have in place, we don't actually have a method to retract a motion that's already been passed. So unfortunately, we're sort of stuck where we are here.
but we can just have a motion that provides findings from both points of view, basically.
Correct.
Because there's no way right now we're going to get a motion to deny it'll be split.
That's what I would encourage you to do, is have findings on both sides. The principal purpose of this is so that the Board of Supervisors is apprised of your opinion and guidance. If this is a recommendation, this is not an approval or a denial per se.
Yeah, we don't have the authority to do that. That's up to the board.
Correct.
Okay, so let's go to public comment, and then we'll bring it back to the commission.
Thank you.
Okay, so our first commenter, John Bartz. Please approach the podium. You'll have 3 minutes.
Good evening. Let me introduce myself. I am John K.J. Bartz, and for the past 47 years, I have worked in the legal, real estate, and construction industries as a consultant, inspector, and expert witness, and I've also acted in that same capacity for government agencies, including the Office of the Attorney General of the State of California, Contractor State License Board, the City of San Jose Building Department, City of Palo Alto Building Department, and the District Attorney's offices of both Santa Clara and Santa Cruz counties. However, This evening I am here as a concerned neighbor and a member of the Live Oak Water Association regarding San Benito County's PLN 220052, the proposed truck stop and Ag Center project near the intersection of Highway 29 and Searle Road. And I'm sure that most of the concerns regarding the location of said project have or soon will be voiced, but there are two issues I wish to address. Number one is the potentially excessive noise created by such an installation. San Benito County Code Ordinance Title 19, Chapter 19.39.030, Article 4 is very specific regarding noise levels in such areas as ours. It states that the created noise levels from such a facility cannot legally exceed 5 decibels above the ambient sound level at adjacent property lines. The nighttime ambient sound level in our area adjacent to the proposed site hovers slightly above 0 decibels. And it would be impossible for a truck stop operating 24/7 to comply with those legal requirements. Further, most of the residents in the immediate proximity of the site are senior citizens, and the oldest, who is 95 years old, shares the common property line. And I am sure that that gentleman and his wife should not be subjected to loud, sometimes startling, illegal noise levels, nor should they and others in close proximity to the proposed site have their constitutional right to the pursuit of happiness trampled on by outsiders seeking profits. Therefore, I have contacted the ACLU seeking advice, guidance, and possible future representation. Now, the second concern that at least I have, and I'm sure some of my other neighbors have, is who are these investors? That is something I feel is very important because they are going to be, what do you want to call those ex facto neighbors? We'll never see them, but anyway. And considering the recent federal legislation banning the sale of U.S. agricultural land to foreign investors and countries, I have contacted the Federal Bureau of Investigation seeking advice, guidance, and
Thank you.
possible assistance.
Thank you. Your time is up, sir. Thank you. If we could get the microphone back, please.
Thanks for your time.
Thank you.
Tim Baldwin?
Is that microphone turned on? Okay.
Can you hear me okay?
Yes, thank you.
Perfect. Well, good evening. My name's Tim Baldwin, and I'm here tonight representing Terilyn Burke, trustee of the Burke Trust. I appreciate County Council's keeping the commission in compliance with the Brown Act. I think the way that this matter was agendized, we need to go ahead and move forward with the matter as it's been presented on the agenda. We also appreciate staff's preparation of the draft resolution memorializing the Planning Commission's vote not to recommend approval of the development agreement to the Board of Supervisors, and agree with that the written and oral testimony provided at the September 18th hearing provided ample evidence in support of the Planning Commission vote. We believe, however, that this evidence also supports the inclusion of additional findings. Sounds like very much that you are going to make findings tonight. I ask specifically that you make an additional finding to be added to the resolution. And that finding is that the development agreement is inconsistent with good land use practices, as a development agreement as proposed does not comply with the requirements of CEQA. We believe the county is required to prepare an initial study to assess the necessity of an EIR or negative declaration before approving a development agreement, as a development agreement is considered a project under CEQA as an entitlement for use. That simple finding will let the board know that you believe the development agreement is inconsistent with good land use practices, and I would appreciate that you go ahead and make that finding tonight on the record. I've submitted a letter directly to you requesting the planning commissioners make this additional finding in the resolution, and respectfully request the commissioners approve the resolution today with the finding. Thank you.
Thank you.
Seth Capron, please approach the podium.
Hi, Commissioner, or Chair Gibson and Commissioners. I spoke with you about this at the last hearing on this. I just wanted to follow up and say that I think I really agree that it would be really bad planning to pass this development agreement without going through the EIR process. I think reading through the material, I know it's legally complex, that technically you're not approving the project, but I'll bet you dollars for donuts that if you pass the development agreement and the project isn't ultimately approved, you will get sued by the applicant, and we'll probably end up settling with them. But I just think from a planning process, you know, there are issues raised by the Burke's attorney and the previous person who spoke about noise levels and light levels for people who've been living in a rural location for years. The magnitude of this project, I think, really needs to be analyzed, and the EIR work that was done as part of the general plan really doesn't address the specifics of this project. It would be the important things that you'd want to look at in deciding whether it was appropriate for this space. As I said at the last meeting, I support a no vote on Measure A. I'm not an anti-development person, but I think that the magnitude of this project in this location is incompatible. I think if you lived in one of the adjacent properties, you would find this totally unacceptable and would want to move. And I think that's a good criteria for you to say this is not appropriate for the location. Thank you.
Thank you.
Annette Perez, please approach the podium.
Hello, Commissioners. My name's Annette Perez, and I would just want to encourage you to not approve this. The benefits of this proposal seem to not outweigh the detriments that would be to our county. The extra greenhouse gases that could be created if this proposal moves forward with this truck is not acceptable. Therefore, I believe an EIR also would be need to happen. There is a high school nearby, and trucks bring all sorts of interesting characters and a lot of extra possible drug activity, nighttime use, and so forth. And I just think with a high school right down the street that this is not a good idea. Just please stay with your decision and give them reason why this is not recommended to just go with supervisors. Thank you very much.
Thank you.
Maureen Nelson, please approach the podium.
Hello and good evening, and thank you for the opportunity. It's been a while. I find this to be a backdoor method if we go back to litigating and deciding on this project, because there is no EIR. That is a requirement, an environmental impact report. What does it hold to our county, to the landowners, to the residents that are going to be living beside this project? I also want to talk about what kind of impacts could potentially come from this project. There are students at Anzar High School. High school is a very rough time for many students. It's a very precarious time for many parents of students in high school. They're exposed to drugs, they're exposed to seedy behavior. And when you have a truck stop near a high school, it just seems like an invitation to lure young adults, male and female, into seedy operations, potential abuse, sexual attacks that could happen. You're also looking at noise, air pollution, water pollution, and the taking of properties from the residents that are beside this location. So I think that the vote that was taken previously needs to be held. I appreciate the fact that not all were present, but I hope that Celeste hears our words and our concerns about behaviors that tend to be stereotyped, but often come to fruition, that are associated with such areas of commercial development. And we don't need to expose our teenagers to any more risks in society than they already have. Thank you for your time.
Thank you.
Stacy Batista.
Are there any more speaker cards? If you have speaker cards, please bring them forward now. Thank you.
Hi. Okay. So we're supposed to talk about the pros and cons, right? So I'm gonna go through my list real quick, because I know you guys have all heard this before. So the development will be located next to our rural residential homes that rely on well water. Concerns for water quality from leaking fuel tanks, runoff from parking lots, and location of development, septic and sewer. It's basically right next to our wellhead for our water community. So that's a concern, of course. And I'm just wondering, I had said this before, is it possible for them to have like a insurance policy for all the homeowners in the area and the high school? If the water contamination happens, my house is gonna be worth $0. And I'm not gonna be able to sell it. So, I'm wondering if the county protects us, or the development has to protect us, or do we have to buy our own insurance? I don't know, but that's a concern. Fire safety. I read that this project is located within the high severity wildland urban fire severity zone. And Aromas, because we're in the county, Aromas is gonna be the responsible fire department. They're a bit of ways, and their backup is gonna be Hollister, which is 27 miles. When Aromas caught fire, was that a year ago? That went pretty quick. And we were all asked to vacate, and we all hung out at the high school, which was pretty scary for us, because that's the first time that's ever happened. Policing of a truck stop where illegal activities was brought up. We don't have a police department in San Juan. I think we have one sheriff guy that kind of hangs out, and that's it. We don't have anybody else. We've called the county, the department, and we can't get anybody to come out. So I'm just a little bit concerned. Is the development going to have to provide their own security? I mean, that could be an idea. Then the county doesn't have to pay for it. Traffic concerns. Whew, went through that new roundabout. Holy crap, that was something that today to try to get to the meeting. If it's going to be something like that, it's going to be crazy. Noise concerns, water quality. I don't know the time yet. And again, like the high school, if you think that you put in a 16,450 square foot convenience store and food hall, if those high school students aren't going to be crossing that freeway, you're crazy, because that's what high school students do. They're going to be looking for some place to go hang out that's got snacks. And I don't know that that's really going to be that safe. That's it.
Thank you.
Through Zoom, Adriana, you've been allowed to unmute yourself.
Hello, I'm sorry I can't be there in person, but I would like to briefly stand in support of my neighbors in opposition to this. We choose to move to San Benito County to raise our family for clean air and clean water and safe streets, and unfortunately that this feels like it would be not conducive to those things. So I just wanted to add my voice. Thank you.
Thank you.
Okay, Jessica Holander, you've been unmuted.
Good evening, Commissioners. Thank you for the opportunity to comment. My name is Jessica Holander. I'm the Environmental Associate with Green Foothills, a nonprofit organization dedicated to the protection of open space, farmland, and natural resources for the benefit of all. Also a resident of Aromas. Green Foothills supports your prior vote to reject the Ag Center Development Agreement. Our main concern with this agreement is that the applicant offered no evidence that the open space easement and wildlife corridor would actually provide any benefit to wildlife or preserve open space wildlife that cannot otherwise be required as mitigation under CEQA. If the applicant would like to move forward in the future with an alternative development agreement, the county should require San Benito Holdings to consult with the California Department of Fish and Wildlife, both Regions 3 and 4, in case of cumulative impacts, the U.S. Fish and Wildlife Service, and a qualified wildlife biologist before approving this development agreement. In addition, the $500,000 offered in the agreement will likely be inadequate to cover the increased cost of road maintenance and public safety resulting from the Ag Center development. And I'm also still curious if you've had the opportunity to consult with your legal counsel to determine exactly what legal rights the county might be waiving if they grant the applicant the vested rights they are requesting. For these reasons and the others laid out in the letter I submitted ahead of the last hearing, I believe this development agreement should be rejected. Thank you very much.
Thank you.
Okay, through Zoom, iPhone, you've been unmuted. Please state your name for the record. iPhone with your hand raised, can you unmute yourself?
Yes, I'm sorry. Greg Weiler, on behalf of the Weiler and Johnson families, the applicant who normally would go first. I would just like to say that we've been a little bit frustrated given the fact that we're a month after the September 18th hearing, and we've gone through the same hearing process again. We appreciate that. We would just like action by the Planning Commission tonight, whether the action is to approve or to disapprove. We don't think any findings are necessary to deny the development agreement. Mandatory findings under the state law are required. County council can advise those and make sure. But as long as we can get a resolution, we had action a month ago, and we filed an appeal immediately, but were unable to proceed because staff felt that a written resolution was necessary, which normally would just be signed by the chairperson, memorializing what happened on the 18th. So whatever you do tonight, we would like to have that done so we can move forward to the board. County councils are already opined as to the applicability of CEQA, and as the chairperson reminded everybody last month, this is not a vote on the actual development. It is just a vote to maintain the current general plan and current zoning. No physical activity, no actual project. That will come in a year or two on an actual application. So everybody's comments tonight are premature, and so we would, on behalf of the applicant, we request action tonight on a written resolution to allow this to move forward on the appeal that we filed and was accepted by the county almost a month ago. Thank you very much, and happy to answer any questions.
Thank you.
Okay, through Zoom, Shelby, you've been unmuted.
Hi everyone, thank you so much for listening to all of our comments. I deeply appreciate it. I'm part of the Burke Trust, and I just wanted to vocalize I understand the last speaker's points, but to sound off on my fellow residents, we don't feel like this as if this is overreacting. We are very passionate about this, and it does directly impact our environment, our economy, and our economy is already suffering. San Juan's lost a legacy of a restaurant just because we don't have enough visitors pass through, and if we have this development, it just encourages people to just keep driving by, and it continues to make us a bedroom community instead of a thriving community like we once were. So in the interest of my own community and kind of our own economy and health, we would like to say no to this project, and we understand that you are voicing that this is kind of not, this won't take place like tomorrow, but to us, this is very serious and this is our livelihoods. Thank you.
Thank you.
Chair, I have no more hands via Zoom and no more speaker cards.
Seeing none, public comment is closed. Thank you all. Back to the commission. Commissioner Toledo, since you were absent the last meeting, you can go first, please.
Thank you to all the speakers who came up and gave their comments. So I am very mindful of all the speakers. Just wanted to run through the pros and cons. So pros would be revenue, and then hire of 1 to 2 sheriffs for the county. Then the cons would be danger to the area from one of the speakers due to interesting characters, noise levels with the individuals living in the area. So I just want to emphasize also that not all truck drivers are criminals. as I know many who make a living, and without truck drivers, we wouldn't have food on our table. So we have the farm to trucks to the stores and then onto our home tables. But I'm very mindful of everyone in the community who lives in the area and do not want this project. So that's about it right now.
Thank you. Commissioner Way?
Thank you. I am concerned about the lack of specificity in the findings. Basically, the only finding that's in the document presented to us is that we believe that the benefit does not outweigh the benefit to the county does not outweigh the cost, basically. I don't think that's specific enough to capture what happened during a multi-hour meeting. I would like to see some more of the bullet points. The things, for example, that Commissioner Toledo Bocanegra was just pointing out, the danger, the proximity to the high school, etc. Those were all things that went into our decision, and if this is going to be presented to the board as a representation of our thoughts, then those need to be captured, as well as capture the thoughts on the opposing side. There were some people, obviously, two, who thought that this was a good idea, and those should be incorporated as well, as you stated. So I guess that's all I have really to state at this point. Thank you.
Okay, thank you. Commissioner Ringhayden?
I think some of the concerns I have is the fact there's no EIR. There's benefits, but I was told from the beginning you have to decide what outweighs one thing or the other. Do the benefits outweigh the detriment? And that's what I'm looking at here. What are the benefits? What are the detriments? And my concerns, the lack of the fact that there's no police department that can quickly get to that location is a problem. The lack of police that can quickly react to that is a concern. The noise levels are concerns. The water runoff, the traffic. And at the end of the day, even though they're not going, this is, just to consider the change, they do want to build. So regardless of it's not a building situation now, it will be shortly. The benefits, the county can sure use the money.
Thank you. Commissioner Scagliotti?
With this project, I think the benefits outweigh the negative in the sense that, Hayden said, this community is in dire need of money. We have to start somewhere trying to make some money. I understand you don't want it in your backyard. I wouldn't want it in my backyard. It's right along Highway 129 and 101. Those same trucks you're talking about park along the side roads to go out to Taylor Farms and True Leaf and all the other ones. So we would just be putting them in one spot. Those trucks are already there. Their reefers are running. They're already there. We're just going to put them in one spot. I do understand where you're coming from, and I feel bad. But this community needs to start making money, or you're going to have no community. So we got to start somewhere. So you better start thinking about it. And that's all I have to say right now. Thank you.
Thank you. Yeah. The problem is that we're putting the development agreement before we even really have a lot of information about the project. So it's a little unusual in that respect, which makes it a lot more challenging because we don't have a lot of facts one way or the other. But as Commissioner Scagliotti stated, we are in need of revenue. One of the conditions of approval could be that they pay for 2 deputies so that there's always coverage there. I mean, there's a lot of things that can be done, but we're not there yet. I think that we should just come up with findings both ways and send it to the board because they're the ones that make the decision anyway. Ultimately, we have no say in this. This is just our recommendation. So, and to be fair to all of us, and we did have that unusual vote where it was 2-2 and we kind of left it there instead of continuing in the item because I don't think we would have had a motion. We couldn't have, a motion to deny wouldn't have survived either. And we would have had to continue it to get our 5-member commission here. So now we're in a precarious spot. So I think the fairest thing to do is just to add findings for both denial and in favor of, and send it to the board and let them do what the board's gonna do.
Can I also add one more thing?
Commissioner Toledo.
As a mother and sometimes commute long distance, wherever our destination is, we do, as the parent, we do make truck stops. And between Gilroy and Salinas, there isn't a location other than the small little gas station that San Juan has that sometimes isn't open. So, and there's no direction. San Juan is out of the way. So having this gas station is a plus for family members. I love truck stops. I like stopping there with my family. I know some people may not like it or see it as a criminal activity location, I don't see it that way. I go in there and I shop the little shops, and we benefit as a family going there. I have family members who work truck stops. My father was a truck driver, so for someone to say that they're all criminals and they have interesting characters is very disturbing to me. But because they're there to make a living, right? Just like all of us. So it is a benefit, I believe, for our county, for the revenue and for the sheriff. And we do have law enforcement. We have CHP that can help us if we need them.
Okay. Does staff have direction, and are you gonna have to bring that back for?
No, I think the goal for tonight would be to form a consensus with each respective side doing that. And then staff can formalize that in writing and then give it to you to sign.
So what additional feedback do you need so you can move forward?
My additional feedback request would be, besides just tonight and all of your points that you made tonight, would you like me to also include the points made at the September 18th meeting, and then include all of those
Yes.
combined?
Yeah, make it, yes, please.
I can do that and incorporate that and get it ready for signature.
Okay, thank you.
Do we want to sort of iron out what those are, or does staff have a good idea of what, maybe we should run through those to make sure we don't have to bring it back?
I don't remember every, let's bring up maybe some of the minutes from September 18th. So the discussion within the September 18th minutes that were just approved included concerns for approach of money in exchange for approval, and the information that it is built into this development agreement, concerns regarding the dollar amount and that it should be increased to $5 million, concerns that if the development agreement is approved but the project is denied, this money would not be owed to the county, concerns for circumventing the will of the people. The open space easement can be added as a condition of the conditional use permit and not part of the development agreement. And then I need some clarification. And then there was a motion as what was included in the minutes. I do know that there was additional discussion on the CEQA and whether there was sufficient CEQA done as part, and then, sorry,
Okay.
go ahead.
Commissioner Way?
Yeah, I just want to point out, it's, well, I don't know how minor it is, but of the 3 items that were proffered to us as benefits, one of them was architectural review of the development, And I did point out, I believe, at that meeting that that was something that we could have insisted on in any event. So there was really no benefit to that.
Okay, we can,
And I think the development agreement as written is sufficient because it's not the last bite at the apple. The $500,000 does not cover everything. It's not meant to. That's not how development agreements work. When the project actually comes to us, there's conditions of approval as well as mitigation measures. So I'm not understanding why there's a confusion from the public that this is it. This isn't the project. This is just the development agreement. Granted, it's a little out of order, but this is not the last say that the county would have for the development. This does not approve the development in and of itself. So there's some confusion of how things work there. But otherwise, I do support it as written. Any other thoughts from commissioners? Do you have any points you want to add for the findings before it goes off to the board?
I do not.
Okay. Is that, we good?
we're good.
Okay. Sean?
I think so, yeah, as long as the commissioners have had their say and they're.
Are we voting on
Yeah.
whether to approve these findings or?
Well,
We can make a formal motion.
Yeah, I would,
Recommendation.
right, I would lay out what's on each side and then have a motion that, solidifies that.
Okay. And it's not it's, what is it even called? It's not a denial or or a
Motion regarding findings?
affirmative recommendation. Okay. So is there a motion to adopt these various findings that we can send this thing to the board so that they can do what they want with it?
I make a motion that we adopt these various findings that we've talked about and all discussed, and we take it and forward it to the board as written down from last meeting to this meeting. On findings on both sides, to approve and deny.
Roll call? Sure. Absolutely.
Oh, we don't have a second yet.
Oh, is there a second? Yeah.
I'll second.
Thank you. Roll call, please.
Absolutely. Vincent Ringhayden, District 1.
You have to help me out a little bit here because I'm a little, so we're just agreeing that we disagree on different findings
Yes.
and
So
then just leave it at that.
Yeah, it's basically yeah.
Excuse me, I'm sorry, I don't think that's the way I would characterize it unless I'm misunderstanding it.
It's whether you would agree with the findings on the side in which you are sitting. So the denial or approval. Are you okay with the denial findings? If
I
you're
am.
on the denial side, if
So-
you're on the.
But it's also adding those findings and formalizing this to go forward to the board.
Correct.
True.
Okay.
But it's not a denial or a recommendation
Understood.
for approval. It's a
Understood.
tie.
Yep.
So I would just stand by my comments and the findings that I don't think that this is a good idea.
Okay. Is there enough to get
Sure.
some language and?
Sure. I think the hope was that they would be more specific. If you just generally have a objection to it, then it doesn't help out the findings that are going to go to the board. That said, you don't need to add anything. It's perfectly fine to move it forward.
The board will do what the
The
board.
important part is that you get to have your say here. This is where you get to.
So I'm just agreeing that what I agreed with earlier is my same position.
Exactly.
I'll stand with that.
Okay. Yes.
Richard Way.
No.
Okay. Robert Gibson.
Yes.
Robert Scagliotti.
Yes.
And Celeste Toledo Bocanegra.
Yes.
Okay, that's a 4-1.
Okay.
I'm not really understanding then because I thought that if so my position is, and forgive me for taking this time, that it's not a yes for me. I do not want this thing. When I say yes, I agree with the findings that I don't.
It's just a yes or no with respect to the findings themselves.
Because it's not going to be a recommendation either way. It's basically, we're kind of a mixed bag of.
There was already a 2-2 vote in the previous meeting. It is a denial. But there's also a tie here. So under the rules of the planning commission, both sides, the chair is to facilitate findings for both sides.
So we all had we all had our statement, right? So you guys disagree, I agree, but we all had our say, right?
Yeah.
So now we're just all okay to move the project forward
See,
to
that's
the,
the problem.
to the,
I'm not.
to the Board of Supervisors, so they can hear our opinions.
This also isn't approving or denying the project in and of itself. This is just a recommendation to the board on a development agreement.
Okay, thank you for the clarification.
Right,
So-
and I'm just voting not to make a recommendation either way to the board, that's all.
Okay.
Thank you for clarifying.
Just a procedural thing because we don't make a decision on development
Yes, sir.
agreements.
Right. Can we re-vote then,
Just to clarify?
to have it absolutely clarified here?
So we're gonna rescind that first vote?
No, just re-vote on it. Let's
Okay,
just
so could we
re-vote
do
on it.
another roll call on that same motion, please?
Absolutely. Vincent Ring Hayden, District 1. No. Okay. Richard Way.
No,
Robert Scagliotti.
Yes.
Robert Gibson.
Yes.
And Celeste Toledo Bocanegra.
Yes.
That is a 3-2.
Okay, thank you. Let it
Thank you.
proceed on to the board. 7.2, hold a public hearing to consider adopting a resolution for PLN 220033, a subdivision of existing 5-acre property into 2.5-acre lots and the construction of a new single-family residence. The project also includes the removal of an existing scenic easement.
Good evening, Chair and Commissioners. My name is Jonathan Olivas, Associate Planner with San Benito County, and this evening I will be presenting PLN 220033 minor subdivision at 494A Carpinteria Road. And we're going to discuss tonight location, project description, CEQA, land use consistency, and staff recommendations. The site is approximately 6 miles northwest of the city of San Juan Bautista in the unincorporated San Benito County in Aromas, about 1.38 miles north of the intersection of Carpinteria Road and San Juan Road. The project is located in a predominantly rural area with some agricultural uses in the area. The project proposes to subdivide an existing 5-acre lot into 2 lots of 2.5 acres each. Parcel 1 will have a new residence with a new septic system and new connection to Aromas Water District. Parcel 2 has an existing residence, existing septic, existing connection to Aromas Water District, and an existing accessory structure. This subdivision will also result in the removal of a scenic easement that was placed on the property in 1975 as mitigation for a minor subdivision as part of a condition of approval for parcel map 218-75. The scenic easement was brought before the Board of Supervisors for direction/discussion in October of 2022, where the board recommended an ISM&D and to hear the results of said ISM&D prior to making its decision on whether or not to vacate the scenic easement. This image shows the site plan, which indicates the location of the existing residence on parcel 2 and proposed residence on parcel 1. The existing septic system on parcel 2 and proposed septic system on parcel 1, the existing and proposed water meters for Aromas Water District, both on parcel 1, and the existing accessory structure on parcel 2. The image on screen shows the project site facing north towards Aromas from parcel 2. The image shows the project site facing south towards Snyder Avenue from parcel 2. This image shows the project site facing west towards Carpinteria Road near the boundary of parcel 1 and 2. And this is the project site facing east towards San Juan Bautista from parcel 2. The project site has a general plan designation of RT. This designation is intended to support traditional rural development as a transition between rural and urban areas. It typically lacks public infrastructure like water, sewer, and drainage, and follows rural development standards. These areas serve as buffers to protect agricultural lands from being converted into urban uses by separating higher density residential areas from agricultural zones. The project site has a zoning designation of RT. The RT district is intended to provide a buffer of rural development between areas of residential development and agricultural areas in order to minimize the conversion of agricultural lands to urban uses. The project is consistent with both these designations. This project aligns with notable policies from the general plan, including policy LU 3.12 and LU 4.1. Policy LU 4.1 emphasizes the importance of housing diversity, and this project directly supports that goal. Parcel 1 will gain a new residence, increasing housing availability. Parcel 2 will retain its existing residents and create an opportunity for additional ADU on both parcels. For agriculturally zoned parcels, LU 3.2 requires that viability for commercial agriculture be proven, but this specific parcel already faces limitations due to its small size. The parcel is too small for large-scale farming, even before the subdivision. Therefore, the project remains in alignment with policy LU 3.12 by recognizing the pre-existing limitations for commercial agriculture. Both parcels meet zoning requirements for 1 dwelling per 2.5 acres. It is also worth noting that this subdivision changes very little about what entitlements would be allowed, as the zoning already allows nearly the same degree of use without the subdivision. To ensure the project's compliance with CEQA, an initial study / mitigated negative declaration, ISM&D, was prepared. In accordance with AB 52, the county sent out notification for tribal consultation, ensuring that all appropriate tribal individuals and tribes had the opportunity to comment on the project. The ISM&D, based on technical reports and analysis, identified several mitigation measures to address potential impacts in the areas of air quality, hydrology and water quality, biological resources, geology and soils, cultural resources, tribal cultural resources, and noise. The ISM&D also addressed the removal of the scenic easement, and the ISM&D found that with the mitigation measures in place, removing the scenic easement would result in a less than significant impact. However, the Board of Supervisors must approve the removal of the scenic easement for the subdivision to move forward per condition 29. The ISM&D was duly noticed for public review for 30 days from July 15th to August 13th, 2024, and we did not receive any comments during that time. Staff recommends that the Planning Commission review the staff report and review the attached draft resolution, which includes findings and recommended conditions of approval. Staff further recommends that the Planning Commission make the findings included in the resolution and adopt the resolution to approve PLN 220033 minor subdivision tentative parcel map, which includes approving the mitigated negative declaration subject to the conditions of approval found in the resolution. Questions?
Thank you. Does anyone have questions of staff at this time, or should we hear from the applicant if they are willing to speak? Any questions of staff right now? Seeing none, to the applicant, please.
Matt Kelly.
Thank you, Jonathan. I'm Matt Kelly of Kelly Engineering and Surveying, right here in Seminole County. I want to thank the commission and Jonathan and the staff for your time and your consideration. There's one clarification I want to make in the resolution on page 6, down at the bottom, last paragraph. It says the future dwelling would be located on parcel 2 and would be expected to connect to a new well. It will actually be served by the Aromas Water District. I'd also like to bring up condition 25, which requests that all proposed utilities within the subdivision and along peripheral streets shall be placed underground except those facilities exempt by the PUC unless waived by the Planning Commission. I don't have any argument with undergrounding all proposed utilities. However, the condition references the County Code 23.17.003 E and F. The County Code further requires undergrounding of existing utilities for overhead lines on the development side of peripheral streets. The Commission may, at its discretion, waive this if they can make the following findings: that the subdivision is within an area where existing utilities have not been underground. That is true. We're talking about Carpinteria Road in Aromas. The other finding that needs to be met is the surrounding neighborhood is absent of similar improvements, which is basically the same thing. The utilities are overhead. Existing overhead utilities will have no significant visual impact, but we're not proposing new ones. They've been there for decades. Another consideration I would like you to make is that undergrounding the existing overhead utilities of this significance for a single 1,500 square foot home is cost prohibitive. This property cannot be further subdivided beyond this subdivision. This is it's reaching this maximum density. I also wanted to add, I meant to mention this earlier, that the project had the support of former Monterey County Supervisor John Phillips. I appreciate your consideration and I'm here for any questions.
Thank you. Are there any questions of the applicant's representative at this time? Seeing none, thank you, sir. Public comment?
I have no public comment in chambers or via Zoom.
Okay, public comment is closed. Back to the commission. Any thoughts? Commissioner Scagliotti?
Yeah, I have one concern. We're gonna lose open space on this, right?
Correct. If we agree to this, then the board will make the decision to delete the open space.
Well, that was there for a reason.
I would agree.
Why are we gonna take it out now? I mean, that doesn't make any sense to me. And why so quick? I mean, there's been some other projects that came before, and it took them years to get it done. This seems to be going really fast. I'll have to consider that. Thank you.
Okay. Commissioner Way?
How big is the scenic easement?
Currently, it is only this parcel that is left in it, so it's about 5 acres or so. The rest of the easement has already been lifted for previous projects. And it is worth noting that the scenic easement was in lieu of the actual recommendation for mitigation for CEQA for the original 1975 project, which was a deed restriction preventing further subdivision. And this was by the applicant's request to put in its place.
Got it.
And it limited development to one per parcel of the original subdivision.
This is almost literally a neighbor of mine. This property is within easy walking distance of my home. I'm very familiar with it. I walk past it periodically. So, yeah, I can definitely vouch for the fact that the existing power lines and such are not undergrounded. And to the best of my knowledge, there's nothing nearby that is undergrounded for that matter. So, yeah, I'd be fine with striking that. And I think that's the only comment that I had at this point.
Okay. Commissioner Toledo?
Okay, so I do have some current concerns in regards to the scenic easement that Commissioner Scagliotti was mentioning. As far as, can you further explain why this property, because there's been other applicants who have applied, and unfortunately they've administered, or I guess, staff has delayed their process because they've had to find another location to have open space, right? So can you tell me why this particular one is going smoother than the other applicant?
Well, the other applicants would be sort of a case-by-case basis, but this one in particular, this was, as I said, we brought it before board in 2022 of October, and that was when they recommended to us to start the ISM&D, and the reason for that was to look at this scenic easement as well, because originally it was part of a parcel map that was, well, it was 4 parcels at the time in 1975, and its purpose originally was a deed restriction that was for a CEQA mitigation measure to because of some landslide issues and other things that were associated to the other parcels that have since been removed from the scenic easement.
Okay.
And this is just sort of the remainder of that. The applicant at the time in 1975 requested this of the board in lieu of being restricted to no further subdivision. And the idea was that the scenic easement was supposed to limit development on the original 4 parcels to 1 residence per parcel.
For this particular project?
Correct.
Okay.
And so now that has changed because the board has agreed in the past to lift it for Aromas Water District and to lift it for the Moritz property right next door to it. And this is the only parcel that is left in it. And it is essentially the original purpose has already kind of sort of expired in a way,
Right.
because it's already been
And
built.
completely understand that. So now my problem is that the other applicants who, I don't want to mention by name, but I'm not sure if you know who I'm speaking of, but other applicants have been delayed the same process. And I believe it's due to them having to find another parcel in our county.
And so there's also two different things. This one is an open space easement versus a scenic easement.
Okay.
Those are a little bit different.
Okay, thank you for explaining that. That's why I'm asking. Thank you, Jonathan.
I drove out there yesterday and I looked up and I was like, oh, trees behind the fire station. That's kind of nice. And I was picturing it like without trees in another house. And it's just like, we certainly ruined aromas, didn't we? So I'm not in support of this project. I think we had to leave the open space easement as is and not continue to add more homes out in the rolling hills of aromas.
Can I add one more thing?
Commissioner Toledo.
As far as the utilities, that the applicant stated, wouldn't it be best it be underground instead of over because of the brush? I'm just asking, I'm not sure.
Anything along Carpinteria Road is actually Monterey County, so those would not be our jurisdiction to underground or not underground.
Okay.
But technically, from a safety standpoint, it is better to underground utilities. But I can also see that we have the current circumstance of them not being.
Just checking.
Yeah.
Thank you.
Commission, is there a will of the commission? Anyone have thoughts to share? I've already shared where my stance is.
I would support this subdivision. It's in my district. It's around the corner from my house. I know the property. That doesn't strike me as destroying anything.
Okay. Commissioner Hayden?
I just want to get back to what you said about the trees. They have to remove those trees?
14 of them in order to build a house? Yeah.
The CEQA review did say they would have to
do that.
Yeah, based on the location where they want the house currently.
Oh, what kind of trees are they? Oaks?
It's a mix.
But there are some oaks in there, right?
There are some.
Predominantly oak. Which I thought wasn't that a protected tree?
Yeah, not supposed to cut those down, period.
Yeah, it is, but it's a mixture of species, and I believe the species they want to cut down is not the ones that are protected the oak. That's protected the San Benito County oak.
Okay, so what's the will of the commission? Is anyone offering a motion?
I'll move to approve the subdivision with the modification to the undergrounding not to require that at this time.
Okay. Is there a second? Is there a second?
Can I just say something before?
Absolutely.
I understand that the other project is under a scenic I'm sorry, can you tell me the two words that you stated, scenic and
open spaces.
Open space, right? So the other one's scenic and this one's open space.
This one is scenic,
the
other one is open.
Okay, thank you. I just need to take a note of that. Now, I just can't get my mind off of it because I'll be gone in December, right? So there's just certain projects that I hoped that would come before I left. I'm not going to be back. And it's very disturbing that some projects come to us just briefly and some of them take a longer time. And I just want to make sure that maybe staff can work on that. Nothing on you, Jonathan. I'm just saying if we have revenue coming into our county, that's something we need to focus on. We need revenue, not revenue from homes. We need revenue. And I'm not, like I said, I'm not getting mad at you. I'm just saying in general that we need revenue. And it's very frustrating that revenue it just keeps falling behind. Our county is in debt. So thank you. That's it. That's all I had to say.
Thank you, Commissioner Toledo. Is there a second for this motion, or will the motion die for lack of a second? And then what are we going to do after that?
If there is no second, I would be willing to delete my removal of item 25 if that would cause people to wish to make a second.
I mean, so basically, if you're willing to approve the subdivision, there needs to be a second, otherwise we can't go to a vote. So if you're willing to vote for it, then just second the thing, please.
Okay, I'll second it.
Wunderbar. Can we have a roll call vote, please?
Absolutely. All right, Vincent Ringhayden, District 1.
I'm a no.
Okay, Richard Way, District 2.
Yes.
And Robert Scagliotti.
No.
And Robert Gibson, District
No.
4. And Celeste Toledo Bocanegra, District 5.
Yes.
Okay, that's a 3. That's a oh man, that's a 3 to a 2 to 3 denial. Thank you.
So we're gonna bring that back with findings, or how do we?
Denial.
Do we need to set a date certain for that?
We can do it the next meeting.
The next regularly scheduled meeting?
Yeah.
Okay. We cover our legal basis so we don't screw it up again, Sean? Very good. Next item on the agenda.
Just really quick, I want to memorialize that the denial findings were going to be based on the scenic corridor, and can you?
Yes.
Mine's based off, I don't want to give up another scenic or any open space easement of any kind. They were put there for a reason. People subdivide and then they come back and say, well, now we don't want to follow up with that previously agreed to item. But yet if you're doing something else, we don't. So let's be consistent. The board always tells the planning commission that we should be consistent. We need consistency from staff.
Okay. And any other additional findings or just the scenic?
Anyone else have another reason?
Thank you.
Thank you.
I have a reason. I just want all applicants to be equally.
That would be nice, yes.
Fine.
Okay, 7.3, continue the public hearing to review amendments to Title I General Provisions and Code Enforcement to a date certain of November 6, 2024 at 6 p.m.
Our code enforcement officer isn't here today, but we needed additional time to put that together.
Okay. Is there any public comment on the continuance of this item until the 6th of November?
There is no public comment in chambers or via Zoom.
You sure? Maureen, you good? Okay, then we need a motion from the commission to continue this item until November 6th. Is there such a motion?
I make a motion, we continue this item 7.3 till November 6th.
I'll second.
All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Hearing none. Motion carries 5-0. We're just chugging along this evening. 7.4, review and adopt the attached resolution that recommends that the Board of Supervisors adopt the attached proposed draft ordinance provisions to amend section 3.05.051 Planning Commission meeting duties, operation, etc.
All right, Goodspeed, Principal Planner, and what's before you was what was agreed upon at the last meeting, and I'm happy to take any questions.
Do you have any questions before we go to public comment? Nope. Public comment, please.
I have no public comment in chambers or via Zoom.
You're breaking my heart, ladies. Okay, public comment is closed. Back to the commission. Anything to say to the supervisors when they ponder this item? That you agree, disagree? We don't want to amend the language of it, but we should send a message to the board whether or not we think they should actually do something with this proposed amendment to the ordinance, or if they should file it in the round file. I myself think that they should make a change because, in my opinion, things aren't working too well, and I think the commission should have a little more say in what goes on. Any other commissioners have thoughts?
I have the exact same thought. Give us a little more bite so we can get something done in this community.
Commissioner Ringhayden?
I would agree with those two sentiments.
Commissioner Way?
Yeah, at the risk of opening a can of worms, item I seems to imply, and I know you said we're not discussing the language, but I have to at least ask the question about this, and maybe I'm just not understanding it. Page 280 of our packet. Item I at the very bottom of the page seems to imply that the Planning Commission has the authority to negotiate and make recommendations to the Board of Supervisors regarding development agreements. It seems to me as though that authority has been vested in ad hoc committees constituted by the, by the Board of Supervisors with their advice and consent. And those ad hoc committees typically consist of a supervisor and one or more planning commissioners. And so this sounds like we're taking the authority away from the Board of Supervisors?
No, this is just basically codifying how things should or could work.
Okay.
Because they're the ones ultimately that would allow us to participate.
May I say something?
Yes.
And I also think it makes these development agreements a little more transparent as to what's going on if you have more eyes watching what's going on.
Oh, absolutely, but,
That's why I want to leave that there like that. That way we have a part of it.
That's why it's a may.
That's why it's a may. We should be there because these development agreements,
But ultimately,
awful gray.
yeah, we serve at their pleasure. So if they don't want us, they will tell us.
okay.
But it's up to the board at the
With the
time.
presence of may as opposed to shall,
Yes.
it's fine, thank you.
Okay. Is there a motion then to send this on to the Board of Supervisors as written? Then I'll try it once. Calm down. I'll move that we send this resolution to the Board of Supervisors as written. Is
I'll
there-
second.
All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Hearing none. Motion carries 5-0. Woo. Any commissioner announcements? Very good. Is there a motion to adjourn?
Motion we adjourn.
I'll second.
All those in favor signify by saying aye.
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 Aye. Any opposed?
Aye.
Nobody wants to stay? Okay, we are adjourned. Thank you all very much. Oh, yeah. God, that's coming up fast. It doesn't seem like that's possible.